now our legal analyst guest this afternoon, criminal defense attorney and former prosecutor Marcia Minot, joining us from Atlanta, Georgia. Marcia, great to have you on the program. And you are really the perfect person for me to ask these questions of, because you've practiced law on both sides of the courtroom. You understand the concerns that these prosecutors have and the concerns that this defense team has. Tell me your thoughts with what the court ought to do with voir dire now in light of the big civil settlement announcement.
Well, it would help this judge to definitely go back and question the pre-selected jurors before the announcement regarding the settlement. The civil matter doesn't really affect the court in terms of it being an appellate issue, but how the court handles how the information has prejudiced the jurors is what's at issue. I think it's important that the court go back and find out, did you see it? And if you did see it, has it prejudiced you? Do I think any of these jurors that are already pre-selected are going to testify or going to give any statement to the court that it has affected them? I don't think so. I think if you can overlook the video footage and clear your mind and still decide the case based on the evidence, I think even hearing regarding a settlement, you'll still be able to do that.
I sure would hope so. I hope so, Marcia. Tell me, do you think the court ought to fashion some sort of maybe special instruction through this process to make it abundantly clear that these jurors cannot consider that it can't factor in one way or the other, and if they've heard about it, they need to let it go immediately because this case is about something entirely different and with an entirely different standard of proof, as you know?
Well, absolutely. When jurors are sworn, you're sworn as a juror several times. You're sworn prior to the questioning, and once you're selected, you're sworn again. And one of the instructions you're given after you're sworn the second time is that evidence comes from the courtroom, not from outside of the courtroom. And therefore, the court can also remind them, when you're going to do jury charges, you remind them again, as the court, you're going to read charges to them and you're going to instruct them as to what the evidence is in the case. A lot of judges will even tell you lawyer statements are not evidence. So do not consider the statements of the judges or consider the statements of the lawyers. There's several opportunities for this court to make sure that jurors in this case are not paying attention to anything that's happening outside of the courtroom.
Right. Let's take a listen now to some of what one of the members of the state's prosecution team shared with the court in response to defense counsel's arguments this morning.
All I can say to the court is there's some things that the state of Minnesota and this prosecution team can control, and there's some things that the state cannot and does not control. We can control the witnesses we call, we can control the evidence that we bring in, we can control the motions, but we cannot and do not control the civil aspect of the case. We cannot and do not control the Minneapolis City Council, and we certainly cannot and do not control the news cycle.
All right, Marcia, I'm going to have some fun with you because you have so much experience on both sides. Share with us some thoughts that support what we just heard the state saying about why, look, it's not their fault and everything he shared with the court with the announcement of that agreement. And then also give us the opposite side's viewpoint and why this is so detrimental for the defense and the right to a fair trial that Derek Chauvin has.
Well, the state is correct. They're not responsible for settlement of the case. The civil matter is totally separate and apart from the criminal matter. And I'm certain that based on the state's argument this morning, they weren't involved in negotiations, they weren't involved in speaking with city council, and they have absolutely nothing to do with that. And you really don't want to hold the state responsible for any actions that they're not involved in. As it pertains to the defense, though, yes, this is really, really bad for them. And the reason why it's bad for them is because you don't want a juror to believe, just like juror number 51 said this morning, hey, $27 million for you to settle for that? There is a total problem there, because that means you guys did something really, really bad, especially because I have experience in human resources and in unemployment claims. And I know that we cut checks, but we never cut checks for $27 million. So defense is concerned, especially I heard defense counsel say the statements that were made include that there was a unanimous decision from the council. You're afraid of that as defense counsel because you don't want the jurors to think if it was unanimous with city council, it needs to be unanimous with us.
Most definitely. Great points there, Marcia. And we know the intense international interest in this trial, coupled with those COVID-19 restrictions, has really limited who can be in the courtroom. Aside from the people who've been there and who have to be there, like the judge, the jurors, the alternates, Derek Chauvin, his defense team, the prosecutors, the poll reporters, They're allowing only one family member from Derek Chauvin's family and one family member from George Floyd's family to be in there at all times. And that video of George Floyd's final moments in Minneapolis now are etched in the minds of us all. And it really triggered some unprecedented reaction from around the world. And of course, though he died in Minnesota, George Floyd, we know, lived most of his life in Texas, had very deep roots in the community there where he grew up, which was Houston's 3rd Ward. Court TV legal correspondent Julia Janae has more now.
Just south of the Houston skyline is the city's historic 3rd Ward, a mix of modest homes and businesses. There's also a housing project here, built in the 1930s, named the CUNY Homes.
CUNY Homes is one of the projects in Houston, and it's been around for decades. It's a tight-knit community. Pretty much everybody would know each other.
Growing up in my era, CUNY Homes, if you didn't know nobody, you couldn't even walk through the CUNY Homes. I mean, it was pretty rough.
It was a housing project with a lot of kids with a lot of aspirations.
One of those kids with high aspirations was George Perry Floyd Jr., known in the 3rd Ward simply as Big Floyd.
Floyd didn't mind giving me the shirt off his back. You know, he was a gentle giant, as we called him. You know, and he was definitely that guy that you would want to be his friend.
He's a good kid. Good kid. I can't, you know, we all went through some struggles going through what we went through coming up in the projects. You know, you can wake up in the middle of the night, you know what I'm saying, hear gunshots.
Travis Keynes, known here in the 3rd Ward as Muggsy, says people started to take notice of George Floyd when he was just a kid.
Aura about him, you know what I mean? Like, we always knew it would be something that he would make history.
The reaction to George Floyd's death sent people into the streets, first in Minneapolis, then in cities around the world. Many of the protests were peaceful, others were violent. Widespread looting and vandalism left businesses in shambles and local leaders scrambling to maintain order.
I know that there is currently a deficit of hope in our city. And as I wear this uniform before you, I know that this department has contributed to that deficit of hope.
I love Minneapolis. We must restore the peace.
For George Floyd's family and close friends, watching the worldwide reaction was both comforting and concerning.
In Iran, every place you can name, Somalia, France, the Netherlands. I've been getting pictures from everywhere in support of justice for my brother George Floyd. So it has been amazing.
We want people to protest, but just do it peacefully and in a way that, you know, we're not hurting other people. We don't want to see destruction and chaos. That's not going to get what we want.
No matter what transpires in the courtroom, the world will be watching.
If justice is not served, it's going to be real bad. It's not going to be something that people are going to take lightly.
We need change. And whatever that means, I hope that America, everyone, will understand that this doesn't need to happen. And whatever we need to do as a nation, we should get together and make that happen.
His name, his death, this movement is serving as a wake-up call for America to realize that there are some issues that have been swept under the rug for so long that need to be addressed. George made the world stop and look at itself in the mirror.
Big Floyd, man, say, man, I'm back at it, man. I'm just sharing right now, you know what I'm saying? Because, man, people quick to count you out, man, but just so strict on counting you in, you know? One thing about old Floyd, man, I love the world.
All right, I want to bring back in our legal analyst guest now, Marcia Minot. Marcia, let's talk about with homicide prosecutions, one of the challenges is bringing the victim to life, so to speak, for the jury to hear enough about them that they can emote and feel attached, but also you're confined to rules of evidence that don't allow you to do everything you want to do to paint a life picture of someone. Share with me some of the thoughts you have on this case with what the state needs to do, and then what the defense needs to do in refuting that testimony, please.
It's a challenging task. And for the state, you have to be able to present George Floyd as a person and not just a deceased. So I was appreciative of the court in its earlier rulings that Mr. Floyd would be referred to as Mr. Floyd and not just the victim. He also gave that courtesy to the defense by referring to Mr. Chauvin as Mr. Chauvin. So we don't have the defendant versus the victim being used. A lot of times as prosecutors, though, because you're so used to using defense versus, victim, those words are hard to get out of your mind. But you want to humanize them, but you have to be careful because the rules do not permit you to draw sympathy. And you're going to hear that throughout this trial, that the court is going to instruct the jurors that the case is not to be decided on sympathy. You have to be careful because you don't want to draw a case to the attention of the court that is going to argue that you have now prejudiced the case or that you end up in a mistrial because you've crossed that line. So as a prosecutor in the past, I had to be very careful to make sure that I was humanizing, but I was not asking the jurors to ask for sympathy. As the defense, you're going to have to go after the victim in a delicate way because you don't want to see that you're victimizing the victim again. So you have to speak about his actions, but in a way that it doesn't sound like you're trying to vilify him, and refer to him respectfully so that you can stick with just the facts and that not to go after him as an individual.
Very well said. Excellent insight and analysis. Marcia Minot, great to have your expertise on the program today. Thank you so much.